Welcome and thank you for joining us this afternoon, the Science and Technology Law Center's webcast series. We are going to be presenting Understanding Export Regulations today. And here are my esteemed panel here. We have to my left here, Jeffrey Fuchsberg, who is with the Patent Research Corporation and one of our former senior associates here at the Science and Technology Law Center. We also have Ormaechea, who is a registered patent attorney, was also one of the former students of the program. Here we also have Benjamin Bergan, who is a senior research associate currently with the program. And finally, but not least at all, we have Jacob Berger, who is also one of the senior research associates. So what we're going to do is we're going to go through the entire presentation, give you a broad overview of export regulations. That will probably take us about 40 minutes overall, and we'll have 20 minutes at the end for questions. You can send those questions in anytime during the presentations, and we'll read them at the end. And that will be it. So I hope you all enjoy.
Good afternoon. This presentation is meant to be a general introduction to the Export Administration Regulations. They can be found in Title 15 of the CFR, Parts 730 to 774. The general order of the presentation is going to be an introduction to the Export Administration Regulations, the 10 general prohibitions of the Export Administration Regulations, the Commerce Control List, deemed exports, exceptions to the licensing requirements, how to obtain a license, documents and record-keeping requirements, and enforcement in cases. The first question that needs to be answered is, what is an export? Most people would consider just shipping a product to another country an export. The government defines it more broadly. It is the shipment of any product abroad, the removal of any commodity or technology from the United States, the disclosure of technical data to a foreign person, or the rendition of a service for the benefit of a non-U.S. person. In general, the regulations govern two types of items: defense items and dual-use items. And there are multiple regulatory agencies that govern. Some are governed by the Department of Commerce, the Department of Defense, or the Nuclear Regulatory Agencies. The Export Administration Regulations, or the EAR, define or govern dual-use items. So the first question is, what is an item? An item is any product, service, or technology. The next question is, what items are subject to the EAR? So the EAR covers all dual-use items. Those are items that are fit for both military purposes if they are slightly modified, but are generally made for commercial purposes. Items that are not subject to the EAR are those items governed by another regulatory agency, items that are publicly available, or items that contain less than a de minimis level of U.S. origin content. When you're making a license determination under the EAR, there are 5 questions that need to be asked. They are: what is being exported? Where is it going? Who will receive it? What are they planning to do with it? And what else do they do?
Regulations are composed of 10 general prohibitions. The general rule is that a person may undertake transactions subject to the EAR without a license or other authorization unless the regulations affirmatively state such a requirement. General Prohibition 1 sets out the broad scheme whereby you will need a license or a license exception for items subject to the EAR when they're going to a country that requires a license based on the country chart. General Prohibition 2 extends Prohibition 1 to U.S. content that is commingled with foreign content, and General Prohibition 3 serves to regulate foreign produced products derived or that are the direct product of U.S. technologies when they're being exported to Group D and E countries. General Prohibition 4 prohibits exporting in violation of a denial order. This would be when you have lost your export privileges through some sort of enforcement sanction from the BIS. Here you cannot use a license exception to get around this, but you might be able to petition for a special exception. General Prohibition 5 requires a license from the BIS for specific prohibited end users or end uses for a technology. General Prohibition 6 prohibits exports or re-exports to embargoed countries. There's a general embargo for both Cuba and Iran, and special embargoes in place for Iraq, Rwanda, and North Korea. And these all have their own special exceptions, not subject to the more general licensing exceptions found in the Commerce Control List. Exceptions in this case would be for things along the lines of humanitarian aid or special agricultural commodities. General Prohibition 7 prohibits exports or re-exports in support of proliferation activities, specifically weapons of mass destruction, and there are no license exceptions there. General Prohibition 8 prohibits shipping through certain countries. This is a fairly extensive list of countries where you cannot ship through without a license or a license exception, but if the Commerce Control List would permit the item to be directly exported there, with a license or a license exception, it can be shipped through there as well. General Prohibition 9 prohibits the violation of any order from the BIS, any misuse of a license or misuse of a license exception. And General Prohibition 10 prohibits any knowing violation of the EAR. So next we have a decision tree for using the EAR, and while it looks complex, here complexity is your friend because the vast majority of these flows lead to outs where you are not petitioning for a license. The first decision is whether or not your item is subject to the EAR. Items not subject to the EAR would be items explicitly controlled by another agency, such as fissile material, controlled by the Department of Energy, reactor core materials, regulated by the Nuclear Regulatory Commission, or publicly available technology, and there it's best to think of that as meaning published research. So if that's what you're exporting, you're not even dealing with the EAR at all. If you are, the next decision is whether or not your item has an export control classification number in Supplement 1 to Part 774. If the answer is yes, you'll need to look up that listing. If the answer is no, it's categorized as EAR 99, sort of a catch-all for unlisted items. And there you're only worrying about General Prohibitions 4 through 10. If the answer is yes, you will either need to apply for a license or perhaps a license exception will apply, and again, you'll shift over to the no side. If you do have an ECCN, you'll need to consult the Commerce Country Chart and determine whether the reason for control for that item and the country in question has an X in the box or not. If there is an X, you may need a license or a license exception might apply, or if the answer is no, you do not need a license and you can freely export. And if you do have a license exception, again, you need to be mindful of General Prohibitions 4 through 10. But in general, most exports can pass through without a license. So the Commerce Control List breaks down listed items into 10 categories, 5 product groups subdividing those 10 categories. It also lists 5 reasons for control, and those will be essential for applying the item listing to the country chart and determining your license requirements. So you will find the ECCN listing all of the items will be grouped alphabetically and numerically. And the first digit of your ECCN is from the 10 broad categories. And rather than go through this entire list, I'll just point out that number 3 is electronics, and we'll be doing a walkthrough for a polygraph machine. So a polygraph machine would be categorized as number 3 in the 10 categories, and that would be the first digit of the ECCN. Next, each category is subdivided 5 ways with the letter, and here a polygraph machine would be categorized as A, equipment. Next are 5 reasons for control, and these are determined by Homeland Security. We've got national security, missile technology, nuclear nonproliferation, chemical and biological weapons, and then Group 9 catch-all for anti-terrorism, crime control, stability, supply, or UN sanctions. And a polygraph machine would fall under Group 9 for crime control. So 3A9 we know would be the first 3 digits for the ECCN of the polygraph. And next we have the alphabetical index, which is a far easier way to locate your item, and we can see that the ECCN number is 3A981 for a polygraph machine. So next we would go to the Commerce Control List in Part 1 of Supplement 1 to Part 774. And we find at the very top a brief description to make sure that we have, in fact, the item we're looking for. And then the license requirements. First, we see the reason for control, CC for crime control. We see it applies to the entire entry, and most importantly, under country chart, we see CC column 1. Next would be license exceptions if they applied, such as LVS for a limited value shipment. If a license exception did apply for a limited value shipment, we would see a dollar amount here that would equate to how valuable a shipment in 12 calendar months can be shipped without a license. So here we see country chart column 1, crime control column 1 rather, on the country chart is what we will use. And then next up we have the commerce country chart. And so if we wanted to export a polygraph machine to Honduras, we look under CC1 and we see an X in the box. So we will require a license from BES for that transaction. If we wanted to ship that same polygraph machine to Iceland, there's no X in the box on the country chart, and we could proceed without a license from BIS.
Next, we're going to be discussing the deemed export rule. The deemed export rule covers an export of technology or source code to any foreign national within the United States. And when that technology or source code is released to the foreign national, it's deemed to be an export. So what is the release of technology? Technology is released whenever it's made available to foreign nationals for visual inspection, when it's exchanged orally, or when it's made available by practice or application, which would be showing them a manual or instructions on how to build something or use something. The next question that needs to be asked is, what is technology? Technology is the specific information necessary for the development, production, or use of a product. If an item satisfies this definition of technology, it's still governed by the EAR, and you must consult the Commerce Country List to determine whether you need a license exception in order to export it. It's also important to know when to apply for an export license for technology under the deemed export rule. So a license must be applied for whenever you intend to transfer controlled technologies to foreign nationals within the United States, and if the transfer of the same technology to the foreign national's home country would require an export license. To determine whether a foreign national is subject to the deemed export rule, you need to know the exceptions. The exceptions are if the foreign national has been granted permanent residence within the United States, if they've been granted United States citizenship, or if they've been granted protected person status, which is largely applicable to people with political asylum. Other than that, the deemed export rule applies to all foreign nationals. A common issue is individuals who have citizenship or residence in multiple countries. For those people, the country of last permanent residence or citizenship is the country that you would use to determine the applicability of the deemed export rule. If there's any questions on this, you can contact the Bureau of Industry Security and they'll give you a case-by-case determination on that specific individual.
A license exception is an authorization that allows one to export or re-export, under stated conditions, items subject to the EAR that would otherwise require a license under General Prohibitions 1, 2, 3, or 8, as indicated under one or more of the export control classification numbers in the CCL, and items subject to the EAR that would require a license based on the embargo policies described in Part 746 of the EAR. If a transaction is subject to General Prohibitions 5 or 6, the possibility of using a license exception will likely be limited. For example, if the transaction is subject to General Prohibition 5, There are very limited circumstances described in Part 744 that may allow for the use of a license exception. If the transaction is subject to General Prohibition 6, Part 746 of the EAR should be considered to see whether a license exception is available. No license exceptions apply to export or re-export items that are subject to General Prohibitions 4, 7, 9, or 10. Also, special commodity controls apply to short supply items. License exceptions for items listed on the CCL as controlled for short supply reasons are found in Part 754 of the EAR. By using any of the 16 license exceptions described in Part 740, one is certifying that the terms, provisions, and conditions for the use of the license exception have been met. Eligibility to use a license exception may depend on the nature of the item being exported or re-exported, the country of ultimate destination for that item, the end use or end user for that item, or other circumstances surrounding the export or re-export. Although there is generally no need to apply for permission to use a license exception, it should be noted that some license exceptions may include notification, review, or reporting requirements. It is also important to note that certain general restrictions apply to all license exceptions. These general restrictions are described in detail in Section 740.2 of the EAR, which should be reviewed in order to determine whether any of these apply to your transaction. For example, license exception eligibility is generally restricted if your item is controlled to its destination for crime control and detection reasons, or if your item is controlled for missile technology reasons. The license exceptions listed in Part 740 are each identified by a three-letter symbol. Certain license exceptions are only available to the extent specified in the ECCN entry on the CCL. These license exceptions are known as list-based license exceptions and include license exceptions for limited value shipments and shipments to countries belonging to Group B in the countries group identified in Supplement 1 to Part 740. The remaining license exceptions authorize exports and certain re-exports based on the overall circumstances of the transaction. These license exceptions are known as transaction-based license exceptions and include license exceptions for temporary imports, exports, and re-exports, and for encryption commodities, software, and technology. Key points to remember when considering license exception eligibility for a transaction include the following. First, one should determine whether a transaction requires an export license based on the item and destination, or based on General Prohibitions 4 through 10. Then, one should review the general restrictions that apply to all license exceptions to see whether any apply to your situation. Also, it is important to confirm that General Prohibitions 4 through 10 do not preclude the use of a license exception. Finally, be sure to comply with all terms and conditions of the license exception prior to proceeding with your export or re-export. If your transaction is eligible for more than one license exception, you should use the license exception with the least restrictive terms and conditions. Now I'll discuss how to obtain an export or re-export license by using BIS's Simplified Network Application Processing System known as SNAP-R. All export and re-export license applications other than Special Comprehensive License or Special Iraq Reconstruction License applications and their accompanying documents must be filed using BIS's Simplified Network Application Processing System, known as the Redesigned Simplified Network Application Process, or SNAP-R, unless BIS authorizes submission via the paper forms BIS 748P, BIS 748P-A, and BIS 748P-B. SNAP-R allows exporters to submit, among other things, export license applications, re-export license applications, and associated supporting documents to the BIS via the Internet. The system's features include built-in system edits that prevent common errors, the ability to attach supporting documents to the export license application, and the ability for the licensing officer to request additional information through the SNAP-R secure messaging with an email notification sent to the applicant. To access SNAP-R, one must have a company identification number, or CIN, and personal identification number. The procedures and requirements for obtaining and using the PIN are set forth in Part 748.7 of the EAR. The SnapR application process can be described in 4 steps. Once you're logged into the system, the first step is to submit information. To do this, create a work item by filling out the online forms with your transaction information, including who are the parties to the transaction, what's being exported or imported, or re-exported, and what is the end use. If applicable, supporting documentation should be attached as PDFs. Supporting documentation may include an international import certificate / end user statement or Form BIS 711, statement by ultimate consignee and purchaser. After submitting the forms, BIS will start the review process, and you will no longer be able to edit the documents. Also, BIS will assign the application an application control number or ACN. In step 2, you'll receive acknowledgement of your submission. BIS sends an acknowledgement message through SnapR to each authorized user who may access the work item. You can access SnapR and see new messages from BIS on the home page. Step 3 involves checking your application status and messages. Once you've received an application control number, you may use it to track the status of an application via the System for Tracking Export License Applications, or STELA. STELA is accessible by phone and via the internet. However, the phone version is eventually going to be phased out. Also, you should be aware that BIS may send you requests for further information through SnapR. For timely processing of your application, reply to these as soon as possible. In the final step, acceptance or rejection of an application can be viewed from SnapR. If you receive an electronic re-export license, you may ship your items based on the terms and conditions of the electronic copy rather than waiting for the duplicate hard copy on BIS letterhead, which will arrive in the mail at a later date.
All right, I'm going to be walking through the application approval or denial process, the record-keeping requirements, and enforcement of the BIS. In the application review, the BIS will analyze the application and also all supporting documents submitted by the shipper. The BIS will weigh several factors in determining whether to approve or deny the application, including where the item is being shipped to, its end use, and also the reliability of the parties involved. In addition, the BIS may send the application to any other government agency if it so chooses. In approving the application, the BIS will either authorize the explicit transaction that was applied to or a series of transactions in whole or in part. It may just approve part of the application. The license number that is given on the application is used when the shipper will file a shipper's export declaration, which will be discussed later. And also, if there's any questions that arise or any communications with the BIS, the shipper will use the license number when contacting the BIS. In denial, the application, the BIS will notify you with the following 6 items. If it chooses to deny the application. Some important notes are point number 4 is that if it chooses to deny, what modifications can be made to the application, or if the license were to be reapplied for, how you can do that. And then number 6, the appeal procedures, so that you may apply, appeal, and hopefully get the license for your item. For the record keeping, the shipper must maintain almost all records that are pertaining to the transaction for a period of 5 years from the date that the item is shipped. The records include anywhere from memos, notes, contracts, and financial records, anything pertaining to the transaction. There are some exceptions, but they're very few, and for the most part, it's better to be safe and just keep all correspondence relating to the transaction. The records must be maintained in their original form or in a photocopy system where they can be completely and accurately reproduced nearly instantaneously, so that in a hard copy for inspection by the BIS. Because the shipper may be asked to produce the records required to be kept by the BIS at any time and by any government agency. There is no warrant required. They can come in and demand all records to be reproduced at their desire. In addition, you must file a shipper's export declaration with every item shipped, or an automated export system The automated export system is the same thing as the shipper's export declaration, only it's automated report filed electronically. Both must contain basic information such as the parties, a description of the item, and a license authority. Failing to comply with the BIS regulations can result in both criminal and civil penalties, including a denial of export privileges for any transaction that's subject to the EAR, complete denial or a partial denial. Civil penalties have been more common because the BIS does not have to prove an intent to violate on behalf of the individual or company. Criminal penalties can face up to $1 million fine per violation, and an administrative penalty can face up to $250,000 per violation. In addition, if a person willfully violates the EAR by exporting an item that is controlled for national security reasons, they could face up to 20 years in prison. Some enforcement statistics from the 2008. The BIS prosecuted more than 40 individuals and businesses for criminal violations, resulting in $2.7 million in criminal fines and 218 months of imprisonment. In addition, the BIS completed 56 administrative cases, which resulted in a total of $3.6 million in administrative penalties in 2008. Now we're going to walk through a few sample cases that we chose, some of it just because of the sheer value of the fines and the denial of export privileges, and how they may relate to your company. In 2005, PA Inc. of Texas was attempting to illegally export nickel alloy pipes to Iran. As a result, they were assessed criminal fines of $100,000, and they also had a 5-year denial of export privileges for all items that are subject to the EAR. In 2005, also, Bass Pro had a $510,000 administrative fine assessed for the shipping of various gun sights to different locations across the globe. This was an administrative penalty, so the BIS did not have to prove that Bass Pro willfully violated the EAR. Next, in 2005, EMD Biosciences of San Diego was exporting biotoxins to Canada. They were assessed a $900,000 administrative penalty for 134 violations. They were also assessed a 2-year denial of export privileges. Again, this was an administrative penalty, and there was no intent proven on behalf of the violator. Next, in 2005, ProChem of South Africa was fined $1.54 million in administrative fines for resales of U.S. origin cyanide. The parent company of ProChem actually had a license to ship the chemical to South Africa, but then ProChem was re-exporting that chemical from South Africa. So they were in violation of their license agreement and were assessed an administrative fine. Finally, DHL Shipping, this was recently in 2009, were fined $9.5 million in administrative fines, and this was part of a settlement for aiding and abetting shipping to Syria, Iran, and Sudan. And that wraps up our presentation. If there are any questions.
All right, so we have a question coming in. If you have a foreign national employed for your company, how does sharing information with them apply to the release of technology?
Well,
anyone can take it.
Sharing information with a foreign national. Can you repeat the question?
A foreign national that's employed with your company, like right here in the U.S.
The release of technology, any information that would be subject to the EAR, if it would require a license to ship, or perhaps an exception, but it's just subject to the EAR, the release of that information to that individual constitutes an export in the eyes of the BIS. So you would actually need a license in order to release information to that individual if they are employed for your company.
And that license, would you have to acquire a license for every new subject that applies to them, or can
Yes.
you get a general one?
No, you would have to acquire a license for every technology that you're going to release to that person.
All right. Next question is for small other items. Things such as, there's been talks of things like video games and things like that, and regulating those. So, do these regulations apply when you're talking about shipping 3 or 4 PlayStation systems outside of the country?
Well, for a small shipment, that's when the limited value shipment would apply. Limited value shipment license exception, rather, would apply. I'd have to take a look at the Commerce Control List for that specific technology to give an answer one way or the other with respect to a particular video game. But by and large, for small shipments, there are limited value shipment license exceptions.
I want to add, even if the limited value shipment exception does apply, you have to cross-check it. So that would be one of the list-based license exceptions that would cover items in the CCL. But some of the other license exceptions may apply depending on who the items are being exported to, and whether the items are being exported to prohibited nations or for prohibited uses. So if any of those items, even something as innocuous as a video game console, if that could be modified for some other purpose or use that would be barred, that might be something to consider as well.
And okay, we have another question. If you are not certain that a technology applies to being, or is under the umbrella of being, a deemed export, how could I go about finding that out?
Well, you could contact BIS and they'll guide you through that. There's a process also through applying through SNAP-R for a categorization of different items. So it could be done that way as well.
And BIS does have I believe it's a 1-800 number to help you classify an item. If you can't figure out the export control classification number for an item you'd like to export, they can give you a non-binding classification.
We don't currently have any more questions. Would you guys, let's actually go through one quick hypothetical so people can see it all pieced together.
Do you want to do the mass spectrum number? All right, so another example is, say you're shipping a mass spectrometer to I don't know, anywhere, any foreign destination. As Mr. Fuchsberg said earlier, the easiest way to do it is to look at the alphabetical list. So here we would go on the through the alphabetical list and look under section M and find mass spectrometer right there, and get its get the ECCN number. In this case, it is 3A99.B. So then you would take that and look it up in the Commerce Control, and it's following. There are license exceptions, license requirements for the mass spectrometer. Here, the license exceptions, none of which apply. And then in the Commerce Country Chart, the only license that's needed for this item is if it is shipped to North Korea and that is controlled for anti-terrorism reasons. Since it's controlled by national security, if it were to ship to North Korea, a willful violation, if you had knowledge that this was, you could face up to 20 years in prison for it, $1 million per violation if you shipped multiple mass spectrometers to North Korea. But for anywhere else, you would be all right, and it would not need a license.
Well, if we have no more questions, all of us here at the New York State Science and Technology Law Center located at the Syracuse College of Law would like to thank you for joining us this afternoon. If you have any questions, there is contact information both in the slides and the emails for the registration as well. And also, if there's more information you need to know or you would like to know about this subject, post it on our website at which is also located in the materials you received. You will find the full report on this export controls, and that will be able to answer a lot more questions for you. So thank you for joining us, and we hope you enjoyed it.